Cryptocurrencies have become increasingly associated with financial instability, volatility, and risk. A lot of people are aware of the exponential growth in Bitcoin's value over the past few years. But also, a lot of people have heard of catastrophic stories like the collapse of FTX. That exact volatility and risk is why there are interesting implications for securities law and its applicability in the realm of crypto. That's what my presentation is about today. I'll be talking a little bit about the intersection between securities law and our pre-existing securities framework and this new emerging technology of cryptocurrency. Here's a brief roadmap of what I'll be discussing. First, I'll go over what the objectives of securities law even are. Why do we have it? What purpose does it serve? That's important because if we're dealing with a novel issue, like a new technology such as cryptocurrency, we want to make sure that all of the initiatives that we undertake, all of the policies that we enact, follow the same principles of thought as the ones that preceded them, as the securities policies that we enacted prior to cryptocurrency and its emergence. Then I'll talk about one of the most common and yet also deceptively complex issues in securities law, which is what exactly it should be classified as a security and what falls outside the scope of that definition. Third, I'll talk about the position of the Canadian Securities Administrators on cryptocurrency, a position that is reflected by most of the securities commissions in Canada, and how that has developed and evolved over time. Fourth, I'll boil the whole presentation and all of the theory in the first few slides down to two main categories of issues for players in the crypto space and what the legal implications are for them in particular. And then finally, I hope to leave you with a few questions at the end to consider and to provoke some thought going forward as you leave this presentation. So let's get into it. First of all, I want to establish what the objectives of securities law even are. A useful source, a useful authority on this matter is the mandate of the Ontario Securities Commission itself. The OSC has a four-pronged mandate, which was three-pronged actually until just a few years ago, but now it has four elements that it tries to prioritize in all of the policies and actions that it undertakes. Those four prongs are as follows. First of all, fostering fair, efficient, and competitive capital markets. Secondly, to make sure that you're upholding financial stability and minimizing systemic risk. Third, to protect investors from fraudulent practices. And fourth, to facilitate capital formation. Now, you can kind of begin to see how, without even getting into some of the specifics, when it comes to crypto, of course, several of these priorities will be very highly relevant. For example, the financial stability aspect, objective number 2 on this slide, would definitely play a big role in potential crypto regulation, given the level of instability that we've seen at certain points in time in the crypto market, broadly speaking. You can also see how some of these priorities often can compete against each other. And it's the job of securities regulators like the OSC to determine how best to strike a balance between competing priorities. For example, you could have a situation where in order to eliminate a high the level of fraud that occurs in crypto spaces, with scams, crypto scams, or rug pulls, or meme coins and things like that. To avoid all of that, a regulator might choose to enact a very highly stringent degree of regulation, maybe even to the point where the regulator decides to prohibit all cryptocurrency. even though that plays into and supports objective number 3, it might undermine, for example, objective number 4, facilitating capital formation. Because issuers of crypto that use crypto as a tool to raise capital might otherwise not be able to, or might be unwilling to raise capital through alternative means. And so the complete prohibition of crypto might reduce capital formation in the market. So that's what I just want you to take away from this slide, is that going forward throughout the rest of this presentation, just keep in mind the general gist of the priorities that we have when it comes to our securities regulation. From a policy perspective, if we have a purely policy driven perspective on securities regulation, then we're going to want to keep these objectives in mind and have them be at the forefront of our policy crafting, especially when it comes to dealing with novel issues that we previously haven't dealt with, like the emergence of a technology like cryptocurrency. Okay. So, this is one of the most common issues that arises in securities disputes, and it sounds relatively simple, but is actually kind of tricky to deal with when it comes down to it, which is, what exactly is a security? What are the boundaries around the definition of a security? So in the Ontario Securities Act, at Section 1, Sub 1, the Act lists a number of definitions for terms that are commonly referred to in the Act. One of those terms is security. And in the definition for security, there are a number of enumerated categories that are listed. So those categories are much more concretely defined, and they involve definitions. They involve categories that probably constitute the vast majority of the securities on the market. So things like common stock, equity in corporations, and debt-related securities like bonds. They have their own enumerated categories under the definition of security. So all of those enumerated heads are largely undisputed. There might be a little bit of dispute around the edges, but largely they're relatively black and white. There is, however, one category in the definition of security at Section 1, Sub 1, Sub N, you can see over here, Sub N, that is sort of used as the catch-all definition. It's known as the investment contract category, and is sort of used to encapsulate all those securities that don't cleanly fit within any of the enumerated heads under the definition, any of the other categories. So while it is useful to have that type of category built into the definition, you can also imagine that because it's a lot less black and white and it's designed to be much broader, we rely now on courts, we rely on jurisprudence to establish what the scope of that definition even is. What is an investment contract for the purposes of securities law? What falls outside that definition? Well, we have to turn to jurisprudence for that answer. And one of the most important cases on this topic in Canadian law is Pacific Coast Coin Exchange from the Supreme Court of Canada. The Supreme Court in that case looked to persuasive U.S. authority on that matter, including the important cases of Howey and also the Hawaii risk capital test as well. And ultimately, the Supreme Court decided that there were a number of factors to look at to determine whether or not something fit under the definition of an investment contract. None of those factors were dispositive, but together they would paint the whole picture. So while there were a number of factors listed in that case and in that test, I just wanted to highlight a couple of those factors here. One of those factors, for example, was that if there's significant money at risk, or and also a significant amount of risk that the investor is undertaking, then it's more likely to be considered an investment contract for securities purposes. Another factor, and this one I think is very, very important in particular to the crypto context, is the concept of vertical commonality. And what we mean by vertical commonality is that there's this relationship between the investor and the issuer of that investment that involves a degree of reliance on the issuer of that investment for the investor to end up making money, to actually secure a return on their profit, on their investment, sorry. And so in traditional securities, it's very clear what that relationship is and where that relationship exists. For example, let's say I'm an investor in the Apple Corporation. I own shares of Apple. I rely on the Apple Corporation in order to secure a return on my investment, in order for me to profit. I require the Apple Corporation to run its business prudently, to make sure that they prioritize shareholder returns, to generally make profitable decisions, and so on. So I have a degree of reliance on the issuer of the security for me to earn a profit. Another feature of of relationships that involve vertical commonality is that the issuer of that investment will usually advertise the investment as a way for potential investors to make money. And one reason they would do that is because the initial issuers stand to gain a lot by getting people to invest in that investment. So, for example, Apple Corporation, they conduct an offering on the market. They conduct a securities distribution, as it's called, and they issue new securities. They're doing that because they want to raise capital, perhaps for new projects that they want to undertake. And so in doing so, they are strongly incentivized to advertise that investment as a way for people to make money. And that's sort of what they end up doing in a relatively formal way. But Apple Corporation or other issuers of securities will try to argue and present their case to say that, okay, if you invest in this stock, we project that we're going to be doing really well in the future. We project growth, X percent annualized growth over the next Y number of years. And so this is why we believe this is going to be a good investment, just as an example, right? And so that type of advertisement demonstrates that there's also another side of this vertically common relationship in which the actual issuer of the security relies upon buyers and investors in the market to raise capital. So ultimately, it comes down to this. The feature of vertical commonality demonstrates that there is, or refers to the concept of there being this relationship between investor and issuer, in which the investor relies on the issuer to turn a profit on their investment, and the issuer is strongly incentivized to advertise the investment to potential investors as a way for them to make money. Okay, with all of that in mind, let's look at what happens when we look at some of the differences between a cryptocurrency and a more traditional security, like a stock. This sort of begins to paint the picture of why it's not so easy to cleanly map on our securities framework, which we've used for traditional securities for decades, onto an entirely new asset class like cryptocurrency, right? So, and a lot of this goes back to this idea of vertical commonality that I was just referring to, right? For example, let's take a look at stocks, right? Not most of the time, by definition, when you buy a stock, you're essentially buying into a package of rights that give you rights or like a share of rights in a corporation. And that corporation is the actual entity that issued you those shares in the first place. So that corporation relies on you or not you necessarily if you're buying on the secondary market, but the corporation relies on IPO investors to raise capital, and you rely as an investor on the corporation to turn a profit, to enjoy capital appreciation, capital gains, and so on. So that degree of vertical commonality is very obvious. Now, does any of that exist with a cryptocurrency inherently? I say inherently because it is possible for you to have a cryptocurrency that is designed in a very specific and special way. And in a few slides, I'll go over an example of a cryptocurrency like that. But let's just take the general case for a moment. Generally speaking, inherently, cryptocurrencies don't need to have a management group associated with them, right? So there's no management at the top that controls the actual value of that cryptocurrency inherently, right? Again, there can be special cases, but there isn't necessarily a group or a corporation or a group of managers or otherwise that controls the profitability of that underlying investment. And inherently, again, the ICO, the initial coin offering, is not like all the time conducted for the reason of raising capital for a new project that is specifically advertised. So, with that in mind, what that means is cryptocurrencies don't inherently have this degree of vertical commonality built into them that you see is almost standard with a different asset class, like stocks, right? For cryptocurrencies, if I'm a buyer in a particular coin, there's no small group of managers that I will sort of look towards in order for me to continue making a profit on my investment. In fact, also consider that cryptocurrencies are often advertised as being currencies, right? As a way for you to actually transfer wealth, or I should say, as a way for you to conduct payments and so on, right? You can actually pay people from one Bitcoin wallet to another in Bitcoin, for example, or other cryptocurrencies. Let's not look at stable coins for a second. Even just regular cryptocurrencies like Ether, you're able to use these to actually pay people. And currencies are not considered to be securities, just generally speaking. So with that in mind, you can kind of begin to see how cryptocurrencies kind of occupy a much more gray area than traditional securities like stocks. And so what that means is, while maybe stocks is an asset class in and of themselves can entirely be classified as securities, maybe we can't make that sweeping generalization for the asset class of cryptocurrencies. Maybe we need a more fact-specific analysis based on the situation and the facts of every specific cryptocurrency that we analyze. And that is sort of the general position that regulators have taken. Let's take a look at that now. So the Canadian Securities Administrators issued Staff Notice 46308 in 2018. This was sort of during the early stages of the popularization of some cryptocurrencies, especially the big coins. And what they looked at was exactly this question of, are cryptocurrencies, should we consider them to fall within the purview of securities law and securities regulation? What the CSA established, first of all, the CSA reinforced the Pacific Coast Coin Exchange test in general for determining whether something should be considered a security or not. And they sort of boiled it down, the Pacific Coast Coin Exchange test, into three factors that were crypto specific. And a lot of these factors play into, again, the feature of vertical commonality, or the theme of vertical commonality that I referred to a couple of slides ago. So let's look at these factors. First of all, does the issuer of the token, of the cryptocurrency in question, retain or pre-mine a significant proportion of the tokens before the ICO? So, for example, let's say I issue Raza coin onto the market, and before I conduct the ICO, I myself go ahead and mine 10,000 Raza coin. And during the ICO, I issue 10,000 more. Now I have 50% of the entire supply of Raza coin on the market after the ICO. That would be one factor to consider in determining that, okay, Raza coin probably is a security, and I probably engaged in the distribution or the issuance of securities in conducting my ICO. The reason why is because, again, it kind of plays into the theme of vertical commonality, where because of the fact that I have such a large proportion of the coin on the market, I'm able to control I can exert a significant level of influence over the market price and supply of the coin after the ICO, meaning I am able to control the value and control the profitability of the investment. So that degree of control establishes, or at least speaks to, the existence of a relationship of vertical commonality between an investor in Raza coin and myself. Because if I decide, like, my investment decisions can dictate the level of profitability that investors in Raza coin enjoy. Also, from a policy perspective, keep in mind that we always want to look towards these objectives at the end of the day, right? And regulating this as a security would allow us to strengthen objective number 3 over here, protecting investors from unfair and fraudulent practices. And also, probably objective 1, fostering fair, efficient, competitive capital markets, right? Because regulating Raza coin as a security would prevent me, for example, or would create a regulatory barrier from me engaging in unfair practices using my market power over the security. Okay, so that's one factor that 46308 laid out. A second factor is, has the token issuer made statements suggesting that the token will appreciate? And this again goes back to one of the aspects of vertical commonality that I mentioned before, which is that the issuer of a security very often will advertise that security as a way for an investor to make money, because they paint the picture of that security as being something that will appreciate in value either imminently or over time. Now, I referenced the Costco case here on this slide because the Costco case is an interesting one for this specific factor. Costco is a case from the US, and it involved a man named Glenn Turner, who essentially ran a pyramid scheme a few decades ago. And that pyramid scheme was determined to be a security in large part because he, in advertising that scheme, sort of advertised it as a way for people to make a significant amount of money. Use, sensational language and so on, all to play into the idea that if somebody buys this, then there's a very good chance that they're going to end up making money. Now, again, that speaks to the vertical commonality. You're creating this relationship between the investor and the issuer, where the investor believes they're going to end up making money because of statements made by the issuer. So this, I think the Costco case can be used as a very close analogy to a number of different potential situations that arise with cryptocurrencies, because this is a lot of what you see with a number of altcoins, with meme coins that rise and fall on social media. You see for example, social media influencers using their influence to convince their audience to buy into a cryptocurrency using sensational statements, making them believe that the cryptocurrency is going to, explode in value over time. So that is one more important factor to consider when it comes to determining whether a coin is a security or not. Okay, third, has the token issuer indicated that the tokens will be traded on the secondary market? Now, this should be self-explanatory. This should be rather obvious, but obviously, first of all, just a little bit of context. You can have open network cryptocurrencies, and you can also have closed network currencies or private currencies. Closed network currencies are not generally tradable on a secondary market, and they're more sort of akin, if you want to draw an analogy here, they're more similar to shares in a private corporation, for example, shares that you are not able to freely trade on a secondary market. So it should be rather obvious that, for something to be considered a security for the purposes of securities law, we want the holders of those securities to actually be able to dispose of those on an open market where those securities can be freely valued and like enjoy a high degree of liquidity and so on. Okay, keep these factors in mind. Going forward, the CSA continued to expand on these factors. And in fact, the next year they tried to look at this question in a bit more of a concrete sense. They tried to apply, to some extent, the actual securities test, the Pacific Coast Coin Exchange test, to cryptocurrencies, and we got the CSA Consultation Paper 21402 in 2019. In the consultation paper, the CSA drew two important conclusions. So first of all, they stated that Bitcoin, Ethereum, and most other large coins are actually probably not securities. So with all of those factors in mind from before, with the Pacific Coast Coin Exchange test in mind, those big coins are probably not securities, and in large part, again, ultimately going back to the fact that there's probably no vertical commonality that exists in those cryptocurrencies. You have, for example, Bitcoin, which is so widely traded and so widely held by investors all over the world that there isn't any single group of people, any single issuer of Bitcoin that enjoys a high degree of control over the value of that investment through their own actions. The same goes for other large coins like Ethereum. So that's the first conclusion that the consultation paper drew. Remember, the important thing here, the notable thing, is that the CSA is taking a fact-specific approach and not painting the whole cryptocurrency asset class with a broad stroke and defining all of it as a security or not a security. They're trying to take a fact-specific approach here. So, number one, we've established large coins, probably not securities. But number two, and perhaps more importantly, they arrived at a conclusion that platforms, so there are these secondary market platforms known as crypto trading platforms, also called CTPs, that allow people to trade cryptocurrencies in a way that sort of removes the technological hassle for their clients, for their customers, and allows them to trade crypto from their phone or from a computer, from a browser, for example, just as if they were trading regular stocks, for example. So what the CSA said is that CTPs that fall into that category could still be subject to securities regulation, even if the actual coins that they facilitate the trading of are not determined to be securities. And here's the reason why. Because even if the underlying assets traded are not securities, you can have contracts that arise sort of for example, one class of those contracts can be derivatives, right? You can have derivative contracts that arise that are actually legislated or regulated by securities law. For example, in a different context, you could have commodities, right? You could have barrels of oil, or you could have bushels of corn, right? By themselves, those assets are not securities. But if I were to create, for example, futures contracts based on those assets, with those assets underlying those contracts, then those contracts would be regulated by securities law. And those contracts are freely tradable as well, right? So there's a similar thing that happens with these CTPs. What happens is that most of these CTPs, in facilitating trade of cryptocurrencies, they don't engage in immediate settlement. Meaning, if I, for example, have an account at Binance or FTX before it collapsed, for example, if I had an account there, if I submitted a buy order for a cryptocurrency, let's say Ripple, right? Ripple coin, I wouldn't technically own the coin until the actual transaction settled, which is a duty that I'm sort of relying on the CTP to conduct on my behalf. And what that means is there's actually a contractual relationship that arises between me and the CTP. And the CSA calls this crypto contracts, right, with capital C's as a proper noun. So essentially what all of that boils down to is clients of CTPs may not technically be intending to purchase securities, but the CTPs themselves are regulated by securities law because the contracts that they have with their clients don't involve immediate settlement. So they're performing a service for their clients that can be traded with other clients. That is something that falls under the purview of securities regulation. So with that in mind, what that means is CTPs should actually be regulated. If this is true, CTPs should be regulated like investment dealers are, right? Dealers of traditional securities like stocks. Investment dealers have a whole regime of regulation that they have to abide by. And for example, you have to register as a particular type of investment dealer depending on the services that you offer. And you also have to, under certain circumstances, register with your primary regulator, which is outside the, of course, on one hand, you have to register with the OSC or with your provincial securities commission. But then you also have to register with IROC, for example, or a different primary regulator, depending on the services that you offer. Meaning you also have to then follow rules like KYC rules and AML rules. It basically adds a whole bunch of duties for CTPs to follow if they want to abide by securities regulation. Okay, let's keep all of that in mind. After this consultation paper was issued in 2019, 21402, it was expanded upon later in Staff Notice 21327 and also 21329. Take a look at 21327 in this presentation. Okay, so the next year in 2020, the CSA published Staff Notice 21327. They expanded upon the conclusion that they drew regarding CTPs, regarding crypto trading platforms, that they established in the consultation paper from the year prior. And they said that yes, generally speaking, CTPs are regulated by securities law. And the rare situation in which they're exempt is if, number one, the underlying assets that they're facilitating the trade of are not securities or derivatives, number one. And number two, if the trading contract that they have with their clients involves immediate delivery and settlement. So there's no service that the CTP is providing for their clients that involves sort of delayed delivery and settlement, right? Now, just want to establish that is rare for CTPs. Most CTPs don't operate that way. most CTPs involve, if I'm a client of a CTP, I won't enjoy immediate settlement. I'll rely on the CTP to make sure that I get delivered my crypto when, a few days, for example, after the actual purchase is submitted, the purchase order is submitted. Okay, so that makes sense, right? This is sort of just a conclusion that we can extrapolate from the rules that we established in the consultation paper from 2019. But this is essentially where the CSA and the OSC and other securities commissions in Canada, where their position is on CTPs as it stands today. Most CTPs have to register as investment dealers, and there's been guidance to that end in, for example, 21.329, which I believe was published in 2022, if you want to do a bit of further reading. And so CTPs are generally expected today to register with their primary regulators and follow all sorts of KYC and AML rules. Now, keep in mind that anyone in the crypto space and otherwise is able to apply for exemptive relief. And recently, securities regulators like the OSC have been engaging in a lot of exemptive relief, issuances for crypto players to allow them some time, sort of, to get accustomed to and make sure they're compliant with all like relevant securities regulation. But exemptive relief is sort of granted on a case-by-case basis. So generally speaking, this is where we're at right now. This is the regulation that CTPs would be expected to follow broadly. Okay. With all of this in mind, let's say we do take a case in which we have a cryptocurrency that is considered a security, and securities law applies to that crypto. What are the implications of that, practically speaking? We know one aspect of that, right? We know that CTPs now have to generally register as investment dealers and so on. Let's take a look at what the general legal implications are here. So on the right here, I've summarized again what the implications are for crypto trading platforms, for CTPs. Securities dealers, CTPs would generally be classified as securities dealers, investment dealers, and so they would have to follow rules and registration requirements and so on. But there is this other category over here on the left that is interesting to consider as well. If I have a cryptocurrency that I've issued, and that cryptocurrency is considered to be a security, well then, in conducting that ICO, what I've essentially done is I've engaged in the distribution of a security. For securities law purposes, a distribution is essentially when the issuer of a security, the corporation itself or an insider, sells off a significant amount of that security to the general market. There are a number of exempt distributions that you can have, and I guess those would also come into play if you're looking at ICOs. You could have, for example, accredited investor exemptions if the issuer of the security is selling a certain value of that security to a sophisticated investor, you could say. Then it could fall under the accredited investor exemption, which would exempt that distribution from being subject to a number of the regular regulations that a distribution has to follow. But generally speaking, a distribution of securities has to follow regulations like prospectus publication requirements, and then also disclosure requirements, right? So when conducting an ICO, I would, if I'm issuing, for example, Raza coin, and Raza coin is a security, then perhaps I would have to make sure I get approval from the OSC by sending them a prospectus draft, getting receipt back from them, and then making sure my final prospectus is approved before I actually go through with the ICO. That's just one example of a regulation that securities distributors have to follow. Okay, but there are a number of other issuer obligations that that issuers assume when they're distributing securities, and I'll list a few more of them in a couple of slides. Here's one case study. Here's one example when it comes to ICOs. This is the example of a cryptocurrency known as Plex Coin, which was issued by an entity known as Plex Corp, perhaps. And this was a case in the Quebec court that was appealed up to the Quebec court. In the case, they looked at whether the issuance of Plex Coin should have been considered to be a distribution of securities, and whether Plex Coin fell under the definition of investment contracts for the purposes of securities law. And the court held that, yeah, Plex Coin was, in fact, a security. And this goes back all the way back to the concept of vertical commonality that we discussed before. There were a number of features of Plex Coin and Plex Corp that the court looked at to determine that, okay, this is an investment contract, and a lot of those features played to the vertical commonality of the relationship that Plex Corp established. First of all, there was a small identifiable group of people that was behind the issuance of those securities. I believe it was a handful of people. A lot of them were related, and they retained a large number of Plex Coin after they engaged in the ICO. And secondly, they also engaged in a lot of sensational representations about the coin before they engaged in the ICO, stating, for example, that Plex Coin would be used to invest in revolutionary technology, and that investors in Plex Coin would enjoy a high degree of profit because of that revolutionary technology in years to come. So all of that played to this relationship between Plex Coin investors and Plex Corp itself that Plex Corp went out of its way to create. They went out of their way to establish a vertically common relationship with their investors. And that's why Plex Coin's ICO was considered to be a distribution of securities. Again, for the implications, remember that the issuers of securities, the distributors of securities, engage in and adopt a number of obligations that they otherwise would not be required to follow. And some of those include things like prospectus requirements or disclosure requirements, and so on. I'll, again, expand a little bit more on that in the next slide. So to summarize all of this, right, if we establish that a particular coin is a security, well, then what are the implications? Let's go through a few of them. First of all, crypto issuer, the issuer of that cryptocurrency, would be regulated as a securities issuer, unless, again, they seek exemptive relief, which, again, is conducted on a case-by-case basis and is up to the discretion of the securities regulator. But generally speaking, crypto issuer, the issuer of that particular coin, would be regulated as a securities issuer. And generally speaking, issuers of securities have to publish prospectuses, and they have to make sure they do continuous disclosure, do material change disclosure, all of the things that the issuer of a regular security, of a traditional security, would be expected to do. And so perhaps these are the obligations that we would expect of the issuer of a coin that is considered to be a security. One more aspect of this is that as the issuer of a security, you assume statutory liability that you otherwise would not be subject to. So in the Ontario Securities Act, at sections 127, 130, and 138, those are just a few examples, but those sections establish types of statutory liability that an issuer undertakes when issuing securities. The reason why that's important is because at common law, for example, if you are an investor in a security and that security, the issuer of that security engaged in misrepresentation, and then that security fell in value after you purchased it, you could rely on the common law tort of misrepresentation for a remedy. But the problem is that in order to pursue a dispute like that, you would need to meet a very high evidentiary burden. You would need to show in evidence that you actually relied upon the misrepresentation in specific that was incorrect to make an investment decision. That's a very difficult evidentiary burden to prove, even if it is true in a particular case. And so what the statutory liability of sections 127, 130, and 138 do is it allows investors to rely on these statutes to pursue remedies without even having to prove that they actually relied on the misrepresentation in a prospectus, in disclosure, or otherwise. So just consider that to be a higher level of protection for investors in securities. And as we mentioned before, CTPs would have to register as dealers if a particular coin is a security. If that coin is not a security, well then crypto issuers would not have to publish disclosure or prospectuses. Investors would then have to rely on tort causes of action for protection, which might most of the time fail because it would be very difficult to meet that evidentiary burden. And at the end of the day, CTPs might still have to register as dealers for the reasons that we established in the consultation paper from the CSA and also Staff Notice 21-327. So these are sort of the two roles that would exist if a particular coin is classified as a security or is not classified as a security. Consider the broader implications of this as well, right? So if something is a security, well then what that means is the entire regime of securities regulation now is relevant, right? And that degree of regulation might be useful in us. For example, if we take a look at the OSC objectives again, it might be useful in allowing us to protect investors from unfair and fraudulent practices. It might also contribute to financial stability and minimize systemic risk if that risk exists in the crypto markets. And at the same time, the trade-off is that we might undermine capital formation, our objective number 4 here. And maybe we also undermine objective number 1. Maybe we undermine our competitive capital markets. For example, if increased regulation reduces the investment that we have in cryptocurrencies as an asset class, and that makes it so that there's less competition for other pre-existing asset classes among investment funds, like stocks or fixed income asset classes. If investment funds have one less asset class to invest in, then maybe we have less competitive capital markets as well on that end. So ultimately, what that means is, we do probably want to have some degree of regulation in the crypto space in order for us to strengthen and pursue objectives number 2 and 3 here. But of course, we don't want to go too far to the point where we're overly undermining objectives number 1 and 4. Now, where too far is, that's where the remainder of the debate is, right? That's what all of these securities regulators actually discuss. And probably nobody has a black and white answer on that, especially because we're approaching cryptocurrencies in a much more gray way, right? In a less black and white way. We're taking it in a we're sort of applying the investment contract test, the Pacific Coast Coin Exchange test, to every single individual crypto currency. And that's not something that we do with traditional securities, right? Most traditional securities fall under an asset class that's enumerated as a category under the definition of security. And so those are much more black and white. So ultimately, there's a lot of room for debate here. But I hope this so far gives you an overview of the regulation that we have for cryptocurrencies that stems from securities law. So here are a few questions to consider as you leave this presentation. First of all, should we adopt new crypto-specific legislation for securities commissions to enforce? Maybe we should even have entirely new regulatory bodies created to enforce that legislation. Maybe it's not the job of securities commissions to regulate crypto. Maybe we should have crypto-specific commissions to regulate crypto. I guess this goes back to the idea of the enumerated heads under the definition of securities, because if we did have a regulatory framework that dealt with all of cryptocurrencies as an asset class, well, then we wouldn't need to do the investment contract test every single time we dealt with a new cryptocurrency, right? So maybe there would be a higher degree of regulatory certainty if we did adopt crypto-specific legislation, because it would reduce the uncertainty regarding whether securities regulation actually applies to crypto or not. And this sort of links to my second question here. Should we be concerned with the level of uncertainty in the status quo for jurisprudence regarding what a security is and the investment contract test? Maybe it's not a concern at the end of the day. We do have a lot of tests like this at law, right? We have a lot of tests in all kinds of areas of law that deal with issues that are not so black and white. And so maybe it is okay for us to just accept this status quo as it is. And maybe there are a number of benefits that it provides as well. Maybe it's better for us to just have a single regulatory framework rather than having a dual regulatory regime. Maybe that would actually create more inefficiency in terms of how the regulator would function. All of this, these are all open-ended questions. We probably don't have a solid answer to all of this, considering how new all of this technology is. Third, is it even feasible for a lot of coin issuers to comply with disclosure and prospectus requirements? Normally we consider most traditional securities issuers to be sophisticated parties. We think of them as being corporations with expertise in dealing with the issuance of securities. But if we're dealing with, maybe less sophisticated parties that are trying to issue cryptocurrencies on a much smaller scale, for example, well, then is it feasible for those types of issuers to comply with disclosure and prospectus requirements if they would have to comply with those requirements? And if it isn't feasible, then maybe, right now we're dealing with them in a way where we grant them exemptive relief on an individual basis, but maybe we should adopt a new framework that considers whether a party is sophisticated when we apply the regulatory framework to them. Or maybe it's fine as is as well. Again, remember, maybe our degree of regulation would actually hinder some degree of capital formation. It would hinder some cryptocurrency issuers from issuing coins, but that's a trade-off we are okay with, given the amount of protection that we're providing investors. And finally, how do we reconcile the competing OSC mandate objectives in this context? The objectives of the protection of investors, the objective of minimizing financial risk and systemic risk, with the objectives of facilitating capital formation and ensuring competitive capital markets. I think that's the broad thematic question that I want to leave you with at the end of this presentation. So thank you for listening. I hope this was, I hope this elucidated you a little bit on what the situation is regarding the securities regulation of cryptocurrency. And I hope you have a few questions to consider going forward as you leave this presentation. Thank you.